Joining us now, it's Joe DiGenova, legal analyst, former U.S. attorney to the District of Columbia. Joe, good morning.
Good morning.
Joe, Lindsey Graham yesterday was saying that the Horowitz FISA report will be ugly and damning for the DOJ. Do you agree with his assessment?
Well, I don't think there's any doubt that's going to be the minimum. The DOJ they're talking about is the Obama FBI DOJ during the Obama administration, particularly at the end, where there obviously was an abuse of the Foreign Intelligence Surveillance Court and the filing of 4 false affidavits with that court in order to get surveillance of Carter Page. That is an astoundingly bad record by the Justice Department, and it means that the senior people there, Sally Yates, John Carlin, the Assistant AG for National Security, and others, Bruce Orr, who was number 4 in the department at that time, all were aware that there were problems with the applications to the FISA court and did nothing to stop them. That means that people with senior law enforcement power knew that a federal court was being lied to repeatedly by senior DOJ officials. Remember, those applications to the court not only are signed by Comey and others, but they are signed by DOJ officials as well, who go before the court and explain them if they are asked to do so. So this is, I'm not surprised that it's going to be devastating and awful. The question now becomes, what will be the consequences of that? And we shall see.
Yeah, obviously we're wondering if there are going to be punitive consequences, but also I'm wondering if there's going to be any sort of reform to the FISA court process. So when we talk about the Trump campaign being abused by the FISA warrant application process, is that an exceptional thing that happened to the Trump campaign, or are our FISA courts being routinely abused?
Well, it's not acceptable, but here's the point. You can have every reform in the world. Remember, the existence of the FISA court is supposed to be a reform. You recall that the FISA court was created as a result of perfectly constitutional electronic spying that was authorized by President Nixon of foreign officials. So Congress said, well, in order to make this, to be careful, we better have a statute. Now, I happen to think the FISA statute is unconstitutional. I do not believe you can limit the foreign surveillance activities of the president under Article 2. That being said, it was a reform. The bottom line is this. You can have every reform in the world if you have fundamentally dishonest people at the top, like Comey and Brennan and Clapper and Yates and Carlin and everybody else involved in the process at DOJ. It won't matter what the rules are.
Right.
You need honest people at the top.
But there is something sort of dangerous about a secret court process, no, for the American public?
Of course there is. There's no doubt about that. But let's remember, as much as I think the FISA court process needs massive overhaul, every day judges grant search warrants and arrest warrants in secret with only one party there, the government. It's actually worked fairly well for us. Where it hasn't worked is in the area of intelligence surveillance, where there is never any accountability and almost never any knowledge that the warrant was obtained. In the average day-to-day arrest and search warrant, within a matter of weeks, we know there's been an arrest, we know there's been a warrant, we know there's been a search, and we know what's been searched. That doesn't happen in the FISA case. That's the problem. And it's going to be tough to fix it. And again, if you have fundamentally dishonest people at the top, like Comer and Brennan and Yates and Carlin, then it won't matter what the rules are.
Joe, we know that some people went back to Horowitz who previously would not speak with him, and now they are speaking with him. And, of course, that requires him now to go back and re-examine things that he had examined previously. How far back does that set this report? How far in the future are we looking at finally seeing this now?
Well, it has to go back at least to the initial application for Papadopoulos, for Carter Page, which is July of 2016. But it really needs to go back before that, because we now know that the Maltese professor, Dr. Joseph Mifsud, who was the person who engaged Papadopoulos and fed him false intel, hoping that he, Papadopoulos, would feed it back into U.S. intelligence, to frame him and then again eventually get something on Trump. We know that Mifsud actually did a recorded deposition of his activities with the CIA in March of 2016. He was approached in March of 2016 to cooperate with the CIA. That is the earliest known now, for the record, Brennan activity involving a foreign intelligence operative who was an asset of the CIA. So, you know, it's really a question of how far back Horowitz wants to go. He doesn't need to go much before that in order to, you know, do his thing on who lied to the FISA court. So, you know, I don't know what's taken so long, except people are coming back to change their testimony.
As for the release of the report itself, which you just alluded to, the some Republican lawmakers now saying shortly after Labor Day is the expectation. Is that what you believe?
I don't know. You know, at this point, given the number of people who've gone back to change their testimony, that is finally tell the truth, quote unquote.
Yeah.
It's hard to tell, especially since Attorney General Barr does have some authority over when it would be released, and if he thinks that the release might interfere with John Durham's investigation of the criminal activities, or whatever it is, then it could be delayed more. But I can't see any legitimate reason to delay the report on the FISA falsities much beyond Labor Day. If there were a delay, it would only be because of Durham objecting.
Joe, just in the minute we have left here, I thought we'd end on a happy note because there have been some signs of life on the Ninth Circuit. A federal appeals court for the Ninth Circuit on Friday ruled that an injunction that had been imposed by a federal judge in California against the president's asylum rule, that you have to seek asylum in the first country to which you wind up. You can't pass through all these countries to get to the U.S. He said it only applies to states within the court's jurisdiction in the western U.S. So, in other words, that injunction can't go past California, Arizona. It doesn't apply in New Mexico and Texas. Is there hope now for the Ninth Circuit?
Well, the Ninth Circuit is waking up to the reality that nationwide injunctions, for which there is very little support in the law, but for which the Ninth Circuit and its lower courts have been using for the last almost 3 years, are going to end. And they're going to end by the Supreme Court, which, as you know, has already said it doesn't understand why these are necessary. Supreme Court's been a little slow on this, in my view. They should have ended nationwide injunctions with a slap in the face of the Ninth Circuit. Over the last year, they've had many, many opportunities to do so. But the bottom line is, what the rule now allows, the Ninth Circuit is allowing that in Texas and along the border there, if you come across and seek asylum, you can be told you can't. You have to go back to the first country you touched foot on after you left your country. And that would either be Mexico, Guatemala, El Salvador, whoever knows. That's where you must seek asylum. And so that rule is now in effect along the Texas border, so at least for the time being. And it's going to be a while because they've granted oral argument in October.
Yeah.
So it's going to be a while.
So the president makes slow and steady progress against the immigration crisis without Congress. Joe DiGenova, thank you.
You bet.